Good evening and welcome to this forum for the District Court 45. Today is June 6, 2022. This forum will be featuring the three candidates who have filed for District Court 45 in Oakland County, which includes Huntington Woods, Pleasant Ridge, Oak Park, and Royal Oak Township. This is a 6-year term. The sponsor of this forum is the League of Women Voters Oakland area and the Oakland County Bar Association, Detroit Free Press. I am Jerry Burton, League of Women Voters member, and I do not live in this district. Before we begin our forum, I would like to introduce Dean Gassojian for the Oakland County Bar Association introduction. Dean, thank you.
Thank you, Jerry. It's a pleasure to be here. I'm currently the Vice President of the Oakland County Bar Association, and it's our pleasure to host, along with the other groups. Tonight you'll be able to listen as candidates tell you why they believe they are the best person to serve you and your fellow citizens as a judge at the 45th District Court, serving the Charter Township of Royal Oak and the cities of Huntington Woods, Oak Park, and Pleasant Ridge. A judge is asked every day to make important decisions, apply the law, and act as society's referee. If the judge is biased, incompetent, or intemperate, then everybody loses and justice is not served. On August 2nd and then again in November, you'll be asked to make one of the most important decisions voters are called upon to make. Decision as to who should serve as a judge in your district, probate, circuit, and appeals courts, as well as the Michigan Supreme Court. Perhaps the least understood elections are judicial elections. Therefore, the Oakland County Bar Association, in collaboration with the League of Women Voters and the Detroit Free Press, conducts judicial candidate forums in each district and court to help you make the important selection of the appropriate judge, a decision that could affect you and your family for years to come. The American Bar Association, a national association of lawyers that has advised American presidents for more than 50 years on the selection of judges, has outlined the following 8 factors to consider in selecting good, honest, competent, and hardworking judges. We endorse these factors and recommend them for your consideration as well. The first is integrity. Is the candidate honest and open? Has he or she led an exemplary life? And will he or she be an example to those whose cases he or she must decide? The second factor is legal knowledge and ability. Has the candidate demonstrated that he or she knows the law, either by good grades in law school, teaching at seminars, or simply demonstrating that they speak and write clearly and well? The third factor is professional experience. It is difficult to think of a judge who can competently hear disputes if the judge has not had much experience in the courtroom as a lawyer or other equivalent experience resolving disputes. The fourth factor is judicial temperament. Will the candidate be a judge who has a positive attitude, acts professionally, and treats all people with dignity and respect? And most importantly, is the candidate likely to remain impartial throughout all of the dispute resolution process? The fifth factor is diligence. Is the candidate likely to be a hard worker, one who effectively and efficiently manages a caseload and decides cases promptly and always is fully prepared? The sixth factor, what is the candidate's state of health? Is there anything about the candidate's physical or mental health that would interfere with his or her ability to complete an entire term or to perform the duties of a judge? The seventh factor is financial responsibility. Has the individual demonstrated prudence and responsibility in his or her own financial affairs? Does the candidate's record of financial responsibility reflect on whether he or she would serve the citizenry well? And the eighth and final factor is the question of public service. Serving on the judiciary is the ultimate act of public service. Has the candidate demonstrated a worthiness to accept this awesome position of responsibility by showing leadership in other organizations that have benefited the community throughout his or her past life? We strongly urge you to keep these factors in mind as you listen to the candidates speak. And most importantly, remember to vote on the nonpartisan judicial ballot. Thank you very much for your attention and your interest in good government. And now here is Jerry Burton from the League of Women Voters, our forum moderator.
Thank you, Dean. The League of Women Voters, a trusted, national, nonpartisan political organization. Our members do the hands-on work to safeguard democracy. While we never endorse a candidate, we are directly involved in shaping the important issues that keep our communities strong. As a League of Women Voters member, I have the opportunity to contribute in a leadership role such as this and has great impact on state, local, and national issues. If you're interested in learning about how you can make a similar impact, I would encourage you to visit the website at lwvoa.org. The League of Women Voters and the Oakland County Bar Association do not endorse any candidate or political party. The Detroit Free Press may endorse a candidate, but only after the forum. The views of this forum are expressed are those of the candidates, and the sponsors take no responsibility. The candidates in alphabetical order are Judge Michelle Friedman Apple and Brenda Richard. Diane Lynn McCain is also on the ballot and was invited to this forum but has not shown. The format of this forum has been established by the sponsors. We ask the candidates answer the questions with their views only and not interrupt another candidate. The candidates will be asking questions from a panelist, Brian Dickerson of the Detroit Free Press and Jamie Lowe of the Oakland County Bar Association, and questions submitted by the audience. Our screeners are Judge David Lawson and Mike Sloth. The format is followed. All candidates will be given a 1-minute opening statement in alphabetical order. Closing statements will be in reverse order. Candidates will have 1 minute to answer each question in rotation. The moderator may mention the questioner and the candidate before each question. All candidates will be allowed equal time to answer the questions. Judy Bateman, a league member, will do the timing and indicate when the candidates have 15 seconds left and when they must stop speaking. Candidates will begin in rotation with all candidates going first. We will begin our opening statement, 1 minute, with Judge Apple.
Thank you. Good evening. I'm Michelle Friedman Apple, the Chief Judge of the 45th District Court. The 45th, as you heard, serves the city of Oak Park, Huntington Woods, Pleasant Ridge, and the township of Royal Oak. Thank you to OCBA, League of Women Voters, Huntington Woods, and the Free Press for hosting this forum. I grew up and I have lived in this district most of my life. I attended Avery Elementary when it was called Tyler because Mr. Avery was principal. I attended Nora and graduated from Berkeley High School. All my children have attended Berkeley schools. In 1995, I was elected to the Huntington Woods City Commission. 1999, I was elected to the Oakland County Board of Commissioners representing this community. And in 2003, I was elected to the 45th District Court. When I ran for judge, I promised to improve the efficiency of the court, to provide members of this community increased access to justice. I have served as a district judge in this community for 20 years, and I am here to present my record and to make my case for re-election.
Thank you. Ms. Richard.
Thank you. Thank you for inviting me to participate this evening. My name is Brenda Richard, and of course I'm running for 45th District Court Judge. I was raised in Pontiac, Michigan. My father and his brothers were all employees of General Motors. Before I began law school, I started off in clerical positions. At some point, I found myself working for a healthcare organization and worked myself upwards from secretary to an account executive. I finished undergrad as I worked full-time, so it took me 10 years to graduate from undergrad. But I did obtain my degree from Wayne State University and then attended Wayne State Law School. I'm happy to say that I completed law school. I did fairly well, and I've been running my own practice for much of the last 20 years. So thank you again for having me, and I look forward to serving the community.
Thank you. We will now begin our question segment with our forum. We will begin with Mr. Dickerson from the Free Press, and he has a question for Judge Apple.
Good evening. Judge, according to the questionnaire you turned into the bar, you and I have something in common. We'll both turn 66 before the year is out, God willing. We've both been at what we do a long time, so forgive me, but I have to ask you the same impertinent question people ask me all the time. Why don't you retire and make way for some new blood?
I love my job. I do a really good job at my job, and I think I've learned to do it well. I think the experience I bring to the bench, based on not only my courtroom experience, but as I have evolved through the various organizations within the legal community, the education I've had by being sent to judges school, by learning the techniques of being a judge through the courses on self-represented litigants, through my leadership as an officer and president of the Michigan District Judges Association, my leadership on the Rules Committee, my participation in the Legislative Committee. My role in this community as a judge is simply not that I call balls and strikes. I bring to the court a vast experience that I think still benefits the community, and I think I am in a position to continue doing that. And 6 years from now, I can't anymore, so have at it.
Thank you. Mrs. Richard?
Yes.
I believe you're also in your 60s, and you've run for a seat on this court before. 2 years ago, you ran for an open seat in the 45th District, and although you did well enough to advance to the general election in November, you were defeated. What has happened in the last 2 years that makes you a stronger candidate and better qualified than you were in 2020?
Well, one of the things is that I have recently changed employment. I believe that one of the things that makes me a better candidate right now is that I have really expanded my knowledge base. When I ran before, my primary area of practice was family law. So when I would receive questions about criminal law, questions about other types of things, I was kind of green because it wasn't something that I did. Over the last 2 years, actually, I've been working part-time for a nonprofit, and I recently switched to full-time. As a part of my job now, I am exposed to virtually every area of the law, and I have learned so much about landlord-tenant disputes, about consumer disputes. A lot of times people focus on criminal law, but to me, a district court is much more than, it's not designed just for criminals. It's a community, and there are other people within the community who have issues that need to be resolved as well. And I believe I'm able to do that.
Thank you.
Thank you. The next question will be from Oakland County Bar Association member Jamie Lowe. And before he asks his question, I'd like to also, we have a third screener from the Oakland County Bar Association, Shantae Wiltshire. So Shantae, thank you. Jamie.
So this question will be for both candidates.
And you will start with Ms. Richard.
But yes, we'll start with Ms. Richard, and it's sort of a follow-up to your last comment. So during the last several years, a fairly new addition to the district court dockets has been the no-fault provider cases, where a medical provider is typically suing an auto insurance company to recover payment for medical services rendered. Arguably, this involves a much more sophisticated briefing and legal analysis than an average landlord-tenant or credit card collection case and that are typically found in district courts. My question is, how familiar are both of you with the new no-fault law, and are you prepared to handle this type of civil litigation as a district court judge?
Admittedly, I am not familiar with it at all. It is one of those areas that I have not seen in my recent practice, so there are probably lay people who know more about it than I do. But I have an advanced degree, I'm very intelligent, and I have the ability to learn. So I don't believe that learning a new area of the law will be difficult. It's just something you have to concentrate on and learn. Much like being a judge. I'm not a judge now, but I know that they send you to judge school, and I know that they train you to become a good judge. So I believe that I would have the ability to learn whatever I needed to learn in order to perform in the position.
Thank you. Judge Apple, the same question. I'm happy to repeat it.
No, I'm fine, and I'm here to save both of us. There are no insurance agencies within our venue. So as a result, I also don't know anything about first-party benefits because they just don't get filed in our court. So it's that lack of any nexus to this community that's just sort of an ironic or perhaps a lucky happenstance, but they just don't get filed in our court. So no one has to know about it if they're presiding at the 45th district. Good news. Thank you.
Thank you. Our next question is an audience question, and we'll start with Judge Apple. Do you think that any changes to the policies, practice, or procedures to the court are appropriate? And if so, what are they?
I'm not sure I understand. So I have a court that I believe provides resources. I believe I'm a problem-solving court. I think anything punitive is the last resort in my court. So as a result, there are procedures on many different levels involving many different topics. So, for instance, because I was a member of the Legislative Committee of MDJA, I became aware of the funding very early on in the COVID problems and understood that the HARA, which I had never heard of before, in this community would become responsible, the portal for funding. So as a result, I was able to reach out, also understanding that there was legal aid available through this grant, and we were one of the first courts that had a eviction diversion program with legal aid representing defendants and handling the process that allowed people to get the money necessary to avoid eviction. So I'm not sure what new procedures, but I'm very committed to ongoing and changing procedures.
Thank you. Ms. Richard?
Same question?
Yes, ma'am.
I'm sorry, could you repeat it?
Certainly. Do you think that any changes to policies, practice, or procedures to the court are appropriate? And if so, what are they?
Well, again, this is something that's kind of out of my element. I don't work in the court system, so I really don't know what the policy
He'll let us know he's calling somebody.
Okay, Brian, you can't.
Did anybody see the video where the guy had like a cat face?
And whose question was she answering? Jamie's?
Yeah,
And I was second, so we.
right. So maybe we should ask that question again.
Okay, it started,
Not if it was recorded.
yeah, he said it was recorded.
Okay, well, I don't necessarily need to ask it again.
Okay, we had a minor sound problem, and we're back on the air. And the next question will be from Brian Dickerson of the Free Press, and we'll start with Judge Apple.
Judge, your district court encompasses two of the most affluent and least diverse communities in Oakland County, and also two much less affluent and much more diverse communities. As a white judge on an all-white court, what do you do to assure the mostly black civil litigants and defendants who come before your court that they'll get a fair shake in your courtroom?
So I think you have to look at the overall makeup of my court. And the fact that I'm Caucasian certainly is not something I can change, but I'm certainly well versed and understand the community I live in. And so from the moment you walk into the door of my court, there is a consciousness and a reflection of the demographics and the diversity of the district I serve, whether it is male or female security guards, diverse at my front door, whether if your complaint about my personnel is made to my deputy court administrator, an African-American woman who lives in the city of Oak Park and has worked for the court for 10 years, whether you're dealing with the supervisor of my civil department, who is a minority, or whether you're contacting the court to schedule an arraignment and deal with a woman who is Middle Eastern and wears hijab, or if you're in my mental health or vet court, the case managers that those participants are dealing with are both dealing with case managers that are minorities. So my court is, and the work I do is prepped by a very diverse demographic that more than reflects and accurately reflects
Thank you.
the demographics.
Thank you, Judge. Ms. Richard, if you are elected, you would be the first black judge to serve in the 45th District Court. Is that important? And how do you expect the experience of black litigants in your courtroom would be different than the experience of black litigants in Judge Apple's courtroom?
Well, I think it's important to the degree that one of the things that we have all been talking about really for the last 6 years, since the beginning of, I can't remember the year and I won't spend the time talking about it, is diversity and inclusion. And that's something that we don't see on the bench in that court. It's very nice to see a lot of people of color who work in the court in lower positions, but those people don't make the decisions when it comes to what happens in that court. The judge makes the decision. And I believe that people who are African American who come to the court will believe that they are being heard by someone who can truly understand whatever they've gone through. Most people of color, myself included, have relatives who have been involved in the criminal justice system, or close friends, or we know people who had to have who were ticketed because they couldn't get their grass cut. So I think that we have a very different experience that's not always seen by the court, and I think that people will appreciate the fact that you're speaking with someone who may have been where they've been, or at least know a little bit more about it. Someone who doesn't have the who does not live in an affluent community.
Thank you. Next question is an audience question, and we'll start with Ms. Richard. How would you deal with lawyers that are unprepared when they appear before you?
Oh, what a hard question. I try to always be prepared when I go to court. I'll just put that out there. But occasionally things happen, and you know, you got caught in a trial. You're just not ready. It depends on what they are there for. If it's something that's going to have some significant impact on the person that they are representing, I would like to think that I would call them to the bench and ask, hey, what's going on? Do you need an adjournment? What else can we do? Because I don't want a litigant to suffer because their attorney wasn't prepared. So I hope that I would take that step if it's something that could not be adjourned. You know, there are carefully crafted questions that answer, like during a trial situation, that will get a fuller story out, something that doesn't necessarily affect the outcome of the trial, but provides the court with more information.
Thank you. Before Judge Apple answers this question, I want to advise the candidates, the camera is out there. I've been doing these candidate things for years, and everybody looks at me, and I don't live here and I don't vote here, so I can't do anything for you.
It's just natural to look at.
It is, and I've had hundreds of these, and everybody looks at me, and the people out there are the ones you want to vote for you. So, Judge Apple, how would you deal with lawyers that are unprepared when they appear before you?
I feel very strongly that the litigants in front of me have the right to be properly represented, whether it's on a criminal side or on a civil side. Oftentimes, especially in district court, you have an attorney on one side and a self-represented litigant on the other side. In any event, I believe if I'm the trier of fact or if I'm going to make the ruling, I have the right to ask questions, get involved, and on my own motion, request information or require parties to provide me or respond to questions that I may have. I have adjourned cases. I have called attorneys up to the bench, advised them that they are not prepared and that we will adjourn the case and give them an opportunity. I have advised unrepresented litigants of what they need to do so that they can properly respond in a case where they are not represented. I've taught the course, and I live the principles that everyone is entitled to be properly represented in my court.
Thank you. The next question will start with Judge Apple, and it's from Brian Dickerson of the Free Press.
I think it's Mr. Lowe's turn.
Oh, I'm sorry, Mr. Lowe.
Okay, so this question is again to both candidates. Excluding your legal career, what real-life experiences either make you a more qualified judge or would make you a more qualified judge than the other candidates?
Well, I was a city commissioner. I was a county commissioner. I learned financing. I learned budgeting. I learned the resources available within the community that I have used and accessed for the benefit of the 45th District Court. One of the first things I did or was able to do when I came to the 45th District Court was create security at the front door. The city of Oak Park wasn't willing 20 years ago, didn't like the visual of a metal detector. But I had sponsored funding as a county commissioner that provided money for all the district courts. So I was able to use that money that was created as a county commissioner and create security in the Oak Park District Court. Resolution, that was the word I couldn't remember. I passed a resolution. Thank you.
Same question to you, Ms. Richard.
Okay, thank you. Well, before my legal career, I worked primarily in sales, and of course, sales is talking, but sales is also listening. And one of the things that I do very well is listen. One of the things that I also do very well is I have a very moderate temperament, I'm going to say, because I listen to people. Sometimes my face can be a little bit expressive, but for the most part, you know, I pay attention to what people are telling me. And for whatever reason, I was blessed with this voice that makes people feel really calm and cared for as they are talking to me. So I think that's, you know, one of the things that I would bring to the bench. The security that I've listened to what they've said, and I've made them feel better just by listening and responding.
Thank you. Next question, we'll start with Ms. Richards, and it's from Brian Dickerson.
Ms. Richard, you wrote in your questionnaire, and I should point out that both your responses are on the Oakland County Bar's website and are available to anybody who has access to a computer. On your questionnaire, you wrote the following: litigants end up in court because they are at a difficult point in their lives. To the degree possible, the court shouldn't add to that difficulty. What do you mean by that? And given that most people end up in court because somebody thinks the law has been broken, how do you achieve justice without making somebody worse off?
Okay, thank you. It's a really good question. One of the things that, like I said, people are at their lowest moment when they appear in court. One of the things that I have experienced in court with some judges, but not all judges, is that the judge adds to the fire. The judge adds to the despair by not giving the litigant the opportunity to tell their full story, by chastising, especially people who are unrepresented by counsel, for either their appearance or for the fact that they're not prepared or for the fact that they really just don't know what they're talking about because they're not an attorney. I've heard judges tell people, the worst I heard is I heard a judge tell someone, get out of my courtroom and don't come back until you have an attorney. That adds to a very bad day. And those are the types of things I don't like to see in court, and they're the types of things I would never do in court if I were a judge.
Judge Apple, slightly different question for you. Are there kinds of cases that you handle differently today than you handled them when you first became a judge? Not because the law has changed, but because you've changed or your perspective has changed?
I think as you become more experienced, you can allow a certain amount of informality or less legalese to come into your discussion or your dialogue or your interaction. It creates comfort, it relaxes people, and I have found that getting rid of the legalese is also helpful. I do something, and it's something I teach at New Judges School, called setting the stage. I announce the case, I announce what type of case it is, I explain to the people in front of me what I know based on what is in the file, nothing that's coming from any place outside, so everybody knows where I'm starting from. If it's an unrepresented litigant, I explain to them what I need to know, what I'm going to inquire. And I don't think I did that initially. I think as I become more comfortable with the process and more comfortable in the courtroom, I have taken the formality out of it. And certainly with Zoom, people showing up without their clothes on changes.
Thank you. The next question will be an audience question, and we'll start with Judge Apple. Michigan statute permits district courts to hold evening hearings to accommodate litigants. Are you in favor of having night court?
So we have tried, and over the years, there have been times. We have not done it. I mean, I think the first couple of years I was there, the biggest issue is money and the finance and the overtime, the additional security and the staffing. So it just becomes cost prohibitive. And actually, it's one of the advantages of Zoom because someone can go out into their car and not have to take the day off work. That's one of the things that I find advantageous. If somebody just has a pretrial, or I'm just doing a probation review, I don't mind if they're sitting in the parking lot, as long as they're not driving. That I have a problem with. But in theory, I have no problem with it, but as a practical matter, I don't think it's something that could easily be accomplished.
Thank you. Ms. Richard?
Same question. I agree with Judge Apple's answer. I believe that with Zoom, a night court truly isn't necessary, to the degree that, because Zoom allows people to spend 30 minutes in their car or in their bedroom or wherever they are, rather than spending, a half hour to drive there, a half the day sitting in court, and then a half hour driving back. So I don't necessarily believe that it's a necessity at this point.
Thank you. Next question from Brian Dickerson of the Free Press for Ms. Richard.
Ms. Richard, I'm going to ask you to use your imagination for this question. I want you to imagine that I'm 25 years old, single, gainfully employed, and you've just found me guilty of driving under the influence of alcohol. I blew a 1.8 blood alcohol test, which is about twice the legal limit. And it's the first time I've been stopped for anything more serious than speeding. What is the range of sentencing options you have, and how will you decide what to do with me?
I don't practice a whole bunch of criminal law at this point, so I'll be honest about that. I believe that the range of sentencing options would be anywhere from probation to, I'm going to say something less than 93 days in jail for a first-time offender. And I forgot the second part of your question.
And how, if that's the range, how would you decide where in that range somebody like me belongs?
Well, I think that my understanding of, and blowing this question, my understanding of criminal law, even though, again, I don't practice this, is that there are sentencing guidelines. I don't know if they're used for misdemeanor cases, which I believe this would be. But I would have to look at the seriousness of the offense the first time, the fact that you are a first-time offender. I'd like to be able to look at whether there was any harm to the community or the potential harm to the community. I do know that I heard in court one day, a judge said, well, you took a 2-ton vehicle, that's a weapon that you had on the road, and I'm going to sentence you accordingly based on your using this weapon in public.
Thank you. Judge Apples, same question. What are your sentencing options, and how do you decide how to sentence a defendant like the one I've described?
There are no sentencing guidelines in the district court. The potential sentence on a case you described is 93 days in jail, fine of up to $500, and up to 2 years on probation. My presumption is, in drinking and driving cases, that it's an isolated incident, and that I have resources to educate you or treat you to make sure it doesn't happen again. But to confirm that understanding, because my first gut reaction is to provide resources and provide the opportunity for a preventative situation, as opposed to punishing. Punishment is always the last resort, especially on a first-time drinking and driving. But anyone in my court goes through what's called screening and assessment that's designed to determine whether or not a substance abuse exists. If there is a substance abuse treatment, that still doesn't mean doesn't mean I'm going to send you to jail. I might require treatment. If there isn't a substance abuse issue, I am going to require some kind of education to make sure it doesn't happen again, some community service, and fines and costs, which are appropriate. There is a cost to drinking and driving in our communities.
Thank you. Next question, we'll start with Judge Apple, and it'll be from Jamie Lowe, Oakland County Bar Association.
So we just dealt with a criminal law question, and I've got one from the civil practitioners. So what is your philosophy or your opinion about the scope of discovery in district court? I mean, if you look at district courts around Oakland County, Michigan, they vary wildly. Some courts offer no discovery, written discovery only. Some limit depositions to 2 per side. Some require initial disclosures, just like in circuit court. Some do not. Some open up discovery completely. What are your thoughts, Judge?
If you want it, you can have it. At your first pretrial, I do a pretrial order, similar to what a circuit court judge or other district courts do. I find out from the attorneys how much they need. Generally, I find 90 days is what most attorneys are asking for. But if there's something more complicated and they need more, I certainly will allow more. It then goes into a scheduling order, discovery cutoffs, witness lists, summary disposition cutoffs. If there is a self-represented litigant, I handle it differently, especially if it's a collection matter. I provide discovery for the self-represented litigant in my pretrial order, requiring, especially if it's acquired debt or purchased debt, requiring the plaintiff's attorney to provide discovery within whatever number of days they say, because sometimes they're going to the original creditor to get that. And I feel very strongly that they're not going to proceed on an affidavit and that they need to have original statements and original credit card agreements before they proceed in my court.
Thank you. Same question to you, Ms. Richards.
Okay, thank you. I agree with Judge Apple about discovery. Just generally, as long as it's relevant, I think it should be allowed, and it should just be set based on, a number of days. How much time do you need to get this discovery done? In my experience, appearing in court without discovery just leaves you open to all types of surprises. It complicates your case. It sets up an attorney for a grievance, because then the litigant believes, well, you didn't represent me very well, because the attorney just wasn't prepared, didn't have all of the information that he or she needed. So I believe that all courts should allow some form of discovery, as long as it's relevant.
Thank you.
Thank you. Next question, we'll start with Ms. Richard. It's from the audience. Can you point to a personal life experience that has helped prepare you to assume the role as a judge who may be called upon to make a life-altering decision?
Well, my really short answer to that question is that most decisions, if you're in court, are life-altering in one way or another. It may be a small amount, it may be a big amount, but most of them are life-altering. As I was maturing into an adult, or when I was a young adult, one of my favorite, well, I won't say favorite, one of the things that people commented, I always said was, that's not fair. That's not fair, when I'd hear something that I thought wasn't fair. And I think it influenced me to become an attorney, because there was just so much unfairness generally in the world. And I had experiences with one family member in particular who got a really raw deal in court. And it made the decision for me that I needed to be an attorney.
Thank you.
Ready?
Judge Apple, same question.
Thank you. I've been very lucky in my life to be mentored by some pretty amazing people. My father was the judge in Oak Park before I was there, and we lost him in February, and the impact he had on the legal community and the number of lawyers who described how he taught them to practice law and told them or didn't allow them to make a mistake while presiding over their cases is a lesson I learned. I also clerked for another great jurist, John N. O'Brien, the Oakland Circuit Court. Another wise man, practically wise man. And I served as his clerk for 3 years, and I observed him in chambers and on the bench, and had the luxury of learning from him as well. I think the fact that I went to law school at night and was able to work during the day allowed me to experience the law in a way that I learned the real side and the scholarly side at the same time, and I was very fortunate.
Thank you. Next question, we'll start with Mr. Dickerson of the Free Press for Judge Apple.
Judge, most crimes involving firearms get bound over to circuit court. Is there anything at all a district court judge can do to mitigate the threat of gun violence?
We have certain policies in our court in reference to firearms, especially if it's a domestic violence or a drinking and driving. And if there is any recovery of a weapon that technically I don't have to seize or I don't have to forfeit, but that's a policy in our court. So if there are even legal guns in a household where a domestic violence situation took place, those are turned over and as part of any resolution are not returned. Similarly, a legal gun in a drinking and driving situation, they could be charged with possession under the influence, but aren't always. We also require those guns to be turned over and not returned. So I agree, in the big picture, I don't have direct impact, but on these smaller cases that appear in front of me, they're smaller in the sense of you can't go to jail for as long, but they're important to this community. And I think those policies impact the safety of the community.
Thank you. Mrs. Richard, do the policies Judge Apple just described make sense to you? And is there anything else you think the district court could do about gun violence?
Well, I think that they do, and I do appreciate Judge Apple being here because I'm getting an education as I sit here next to her, so I appreciate that. I believe that the district court, to the degree that that the court is binding cases over, that they can make a part of the possession of guns a part of a bond condition, as the judge said, but probably in a different way, requiring that the guns be turned over to the court. I think that's a really good policy. I think that the court could add some additional requirements to a bond if someone is found to violate conditions that the court has set down once the person is found over as well.
Thank you.
Thank you. This will be the last question prior to the closing remarks. It'll be from Mr. Lowe from the Oakland County Bar Association.
So,
We'll start with Ms. Richard.
Ms. Richard, we'll end on sort of a later question. What kinds of jobs, interests, or volunteer activities did you pursue during school and law school?
During undergrad?
Undergrad and law school.
Okay. During undergrad, I worked for, I worked for Health Alliance Plan in their marketing department. And I did start a program, a couple of things I did there. I did a coloring contest for the kids because I like kids. So I was involved in that. Then I started, I got Health Alliance Plan involved in, what is that called at Delisle? Youth Day that Ed Deeb used to host. I don't know if they still have it or not, but Health Alliance Plan became a part of that based on my recommendation that we do that. In law school, I participated with HLAC, offering free legal aid as a student, but other than studying and working part-time, I did not have time to do a single other thing while I was in law school.
Thank you. Judge Apple, same question to you.
It's a long time ago. I was a member of my synagogue. I was a member of B'nai B'rith Jewish organizations and did parade-related volunteer work. I believe I also did Israel-related volunteer work. I, in law school, worked full-time and worked with youth assistance when I was in law school, and that was something that I carried forward when I became involved as a city commissioner and a county commissioner and as a judge. And I think that sums it up.
Thank you for your time.
Thank you. That concludes the time for questions. The candidates will now be giving 1 minute to make their closing statement in reverse order, and we will begin with Ms. Richard.
Okay, thank you very much. I just want to say again, thank you for having me here today. I appreciate the opportunity to speak with everyone and to answer some questions. I'm not a politician, obviously. I'm just not. This is my second time running for anything since I left high school, actually. And I am just a little bit of an introvert, so I find this entire process of just a little bit intimidating. I hope that you got a better understanding of who I am. I think that I would make a very fine district court judge, and I really welcome the opportunity to serve this community. So thank you very much.
Thank you. Ms. Judge Apple.
Thank you. Thank you for the opportunity to be here tonight. It has been my pleasure to talk about the job I have loved doing for the past 20 years. I do not have to tell you what I hope to do as a judge or of what type of judge I will be, because you already know who I am and what I have done in and around this community for the past 28 years. The individuals that you have elected and trusted to lead your cities and townships, the mayors of Oak Park, Huntington Woods, Pleasant Ridge, and the supervisor of the Township of Royal Oak, have all endorsed my candidacy. 20 years ago, I promised to protect the safety of this community, to improve security, to increase the services offered by the court, and to always provide access to justice. I believe that I have kept my promises, and tonight I am asking you to vote for me so I may continue to have the privilege of presiding as the judge of the 45th District Court and to continue to have the privilege of serving this community. Thank you.
Thank you. The sponsor would like to thank the candidates for their participation. For further nonpartisan information on these candidates, please check the League of Women Voters website, lwvoa.org, or connect with vote411.com. When known, the rebroadcast times of this forum will be on the League of Women Voters OA website and on the Oakland County Bar Association website. The League of Women Voters is funded by contributions from concerned business and citizens. Our membership is open to men and women over the age of 16. Remember to vote on August the 8th. Remember, democracy is not a spectator sport. Thank you and good night.
Thank you, Judy.